This question about the law of agency asks about, well, when is an agent liable or not liable for a contract? So just as a brief reminder, an agent is somebody who acts on behalf of a principal and enters into a contract with a third party. But because the person is acting as an agent, effectively they drop out of the contract. And what you end up with is the contract taking place not between the third party and the agent, between the third party and the principal. And the agent falls out, removes itself. And therefore, in that situation, the agent, although they might have signed the contract, they are not liable for it because they were acting on behalf of the principal, on behalf of somebody else. So the question here is, when would an agent not be liable for a contract? In other words, when would the agency law apply? Well, we've got three options here. The first option, where the agent fails to disclose that they are acting as such. Now, that's not great, but it's not an automatic deal breaker. So, for example, the agent might not have told the third party they were acting as an agent. Maybe the principal did, and the principal said, "Look, please, when you deal with Mr. Agent, they're acting as my agent." So it's all about what does the third party reasonably believe. And that doesn't have to have come from the agent. So that one looks like it's a possibility. The second option, where the agent intends to take the benefit of the contract and does not disclose that they are acting as an agent. Now, in that situation, the key here is the agent intends to take the benefit of the contract. In other words, they are party to the agreement. And if they are party to the agreement, they cannot drop out. So they are liable. Because they are liable, that is not a valid answer. I'm looking for the situations where the agent would not be liable. And then where the agent acts on their own behalf, although they are holding themselves out as an agent, again, because they're acting on their own behalf, because they're trying to get a benefit for themselves, they are party to the contract. So that is not a valid answer. They will not be able to withdraw from the contract. They will find themselves liable for what they've signed. Therefore, of the three answers, it's part A, it's the first option, where the agent fails to disclose that they are acting as such, they can still not be liable for the contract, even though they haven't disclosed it, because we know that the second and third options, they would definitely still be liable.